Hello students, today we are going to discuss one of the most sensitive and important legislations in India, the Child and Adolescent Labour, Prohibition and Regulation, Act, 1986. To understand why this law was needed, let us look back. Before 1986, India had many separate laws dealing with child labour, like the Employment of Children Act, 1938, the Factories Act, 1948, the Mines Act, 1952, and the Motor Transport Workers Act, 1961. But the problem was, these laws lacked uniformity. Some defined a child differently, others covered only a few occupations, while many hazardous industries still legally employed children. Clearly, there was a gap. The Constitution of India, under Article 24, had already laid down that no child below the age of 14 shall be employed in factories, mines, or hazardous work. But in practice, this was being violated. To correct this, the 1986 Act was introduced. Its aim was simple: to ban child labor completely, and to regulate adolescent labor, especially in dangerous work. This law was also influenced by the International Labour Organization. Out of ILO's 8 core conventions, 2 are directly related to child labor: Convention 138, which fixes the minimum age for work, and Convention 182, which calls for eliminating the worst forms of child labor. For example, Convention 182 makes it clear that no child under 18 should be in work that harms their physical or mental health. India, being part of ILO, had to align its laws accordingly. Now, let's turn to the objectives of the Act. It clearly states, children cannot be employed in any occupation or process, and adolescents cannot be employed in hazardous occupations. At the same time, it regulates conditions for non-hazardous work. The Act is structured into 4 chapters, 1 schedule, and 26 sections. Chapter 1 deals with definitions. For instance, it defines a child as below 14 years, an adolescent as between 14 and 18, and occupier as the person with ultimate control over an establishment. Chapter 2 is the heart of the Act. Section 3 bans employment of children altogether. However, there are 2 small exceptions. A child can help in a family enterprise after school hours, provided it is not hazardous, and can also work as an artist in the entertainment industry, like films or TV serials, but not in circuses. For example, a child acting in a movie is allowed, but a child working in a matchstick factory is not. Then comes Section 3A, which prohibits adolescents from working in hazardous occupations listed in the schedule. Today, there are 38 such occupations and processes, including things like mining, chemical mixing, and handling explosives. To give a real picture, an adolescent may assist in a small shop or farm, but cannot be sent to work in a fireworks factory. The Act also empowers the government under Section 4 to amend the schedule, adding or removing hazardous work depending on new risks. And under Section 5, a technical advisory committee is set up to guide the government. This committee can have up to 10 members and a chairman, and it can also form subcommittees. Friends, in our previous discussion we saw how the Child and Adolescent Labour, Prohibition and Regulation, Act, 1986 protects children by prohibiting their employment and restricts adolescents from hazardous occupations. But what about those adolescents who are allowed to work in non-hazardous jobs? That's exactly what Section 6 to 13 deal with, the regulation of conditions of work of adolescents. Let's begin with Section 6. It clarifies that these provisions apply only to establishments where hazardous work is not carried out. So, an adolescent may work in a tailoring shop or a small grocery unit, but not in a fireworks factory or a chemical plant. Now, moving to Section 7, hours and period of work. The law ensures that adolescents are not overworked. For instance, they cannot work continuously for more than 3 hours without a rest interval of at least 1 hour. Their total spread of working hours, including breaks, cannot exceed 6 hours in a day. Also, no night shifts, they cannot work before 8 am or after 7 pm, and importantly, no overtime or double employment. So, if a 16-year-old is working in a printing press from 9 to 3, he cannot take up another shift in a different establishment on the same day. This protects them from exploitation. Section 8 mandates a weekly holiday. The occupier must declare the holiday in advance by displaying a notice at the workplace, and it cannot be changed more than once every 3 months. Imagine a small bakery that employs 2 adolescents. They must be given a fixed weekly off, just like adults. Next, Section 9 requires every occupier to notify the inspector within 30 days of employing an adolescent. The notice must include details like the establishment's location, the manager's name, and the nature of work. This ensures transparency and government oversight. However, this doesn't apply if the adolescent works only in a family enterprise or in a government-recognized school setup. A practical question arises: what if there's doubt about the age of an adolescent? That's where Section 10 comes in. If an inspector suspects that the claimed age is wrong, the matter is referred to a medical authority. A bone development test or other scientific tests must be done within 15 days. This prevents false claims, either to allow underage children to work or to deny an adolescent their rights. Then comes Section 11, which requires every occupier to maintain a register of adolescents. This register must record names, dates of birth, hours of work, rest periods, and nature of work. Inspectors can check this at any time. Think of it as a mandatory attendance and compliance log. Section 12 adds further transparency. Every workplace must display a notice containing extracts of Section 3A, prohibiting hazardous work for adolescents, and Section 14, penalties. This notice must be in English and the local language, so that even workers and their families know the rules. Finally, Section 13 empowers the government to frame detailed health and safety rules. These include everything from cleanliness, waste disposal, ventilation, lighting, and drinking water, to protection from excessive weights, eye protection, fire precautions, and safe machinery use. For example, if an adolescent is employed in a textile shop, rules about dust control, lighting, and safe use of sewing machines can be enforced. Friends, by now we have seen how the law prohibits child labor, regulates adolescent work, and sets conditions of employment. But what happens if someone breaks these rules? That's where the miscellaneous provisions of the Act, from Section 14 to 18, step in. These provisions are like the teeth of the law, ensuring that violations are not just frowned upon but strictly punished. Let's begin with Section 14, penalties. If an employer hires a child or adolescent in contravention of Sections 3 or 3A, meaning they put a child to work, or assign an adolescent to hazardous processes, the punishment is severe, minimum 6 months to 2 years in jail, or a fine of 20,000 rupees to 50,000 rupees, or both. Right finger, for example, if a factory employs a 13-year-old to stitch footballs or asks a 16-year-old to work in a fireworks unit, both are illegal. Now, what about parents? The law shows compassion here. Parents or guardians are not punished unless they knowingly push their child into commercial or hazardous work. Even then, for the first offense they are excused, but for a repeat violation, they can be fined up to 10,000 rupees. The Act gets even stricter with repeat employers. If a person is caught a second time, imprisonment of 1 to 3 years becomes mandatory. Next, Section 14A declares these offenses as cognizable. This means police don't need a warrant to arrest. Imagine, a child is spotted working in a hazardous dye factory. The police can immediately act, file infer, and rescue the child. But punishment alone is not enough, there must also be rehabilitation. That's why Section 14B creates the Child and Adolescent Labour Rehabilitation Fund. Every fine collected from employers goes into this fund. Plus, the government adds 15,000 rupees per rescued child. This money directly supports rehabilitation, ensuring the child goes back to school, not back to work. Section 14C complements this. Rescued children are rehabilitated under existing welfare schemes. For example, a 12-year-old rescued from a roadside eatery may be enrolled in a residential school funded by this scheme. Then comes Section 14D, compounding of offences. For minor, first-time offences, other than hazardous child labour, the district magistrate can allow compounding, meaning the employer pays a fixed fine instead of going through a long trial. But if they don't pay, prosecution continues. This balances enforcement with efficiency. Now, Section 15 ensures uniformity across laws. The penalties for child labor under other acts, like the Factories Act or the Mines Act, will now mirror the strict penalties under this act. Section 16 explains procedures. Anyone, a person, a police officer, or an inspector, can file a complaint. And, importantly, a medical certificate of age is taken as conclusive evidence. No more endless debates in court about whether a boy is 13 or 15, the medical report decides it. Section 17 and 17A talk about implementation. Inspectors are appointed, and the district magistrate plays a central role. He becomes the chairman of the district task force, appoints a nodal officer, and oversees rescue and rehabilitation. So, in practice, if children are found working in a brick kiln, it is the district magistrate who leads the rescue mission. Finally, Section 17B mandates regular inspections and monitoring of prohibited workplaces. Think of it as surprise checks in industries like carpet weaving or glass bangle units, where children are often secretly employed. And to give flexibility, Section 18 empowers the government to frame detailed rules on everything, from working hours for adolescents, to registers, to the powers of inspectors. Now we are going to talk about the latest amendments in the Child and Adolescent Labour Act. The Act was last amended in 2016. Why was this amendment necessary? Earlier laws banned child labour in only certain occupations, but many loopholes remained. The amendment aligned our law with the Right to Education Act, 2009 and international commitments under ILO Conventions 138 and 182. What changed? First, the definition of child was amended. Now, no child below 14 years can work in any occupation or process, except in family enterprises after school hours or in entertainment, like TV or films, but not circuses. A new definition of adolescent was added for those between 14 and 18 years. Adolescents can work, but not in hazardous industries. For example, they cannot be employed in mining or fireworks. The amendment also inserted Section 3A, banning adolescents from hazardous occupations. It tightened penalties. Employers face 6 months to 2 years imprisonment and fines up to 50,000 rupees. Even parents can be fined if they push children into commercial labor. A new Section 14A made offences cognizable, meaning police can act immediately without a warrant. And the district magistrate was given powers to enforce the act. But law alone was not enough. Back in 1996, the Supreme Court, in the landmark case of MC Mehta vs State of Tamil Nadu, gave historic directions. The court ordered surveys to identify working children and immediate withdrawal of children from hazardous industries. Employers had to pay 20,000 rupees per child into a child labour rehabilitation cum welfare fund, while governments had to provide an adult family member with work, or else contribute 5,000 rupees more. The idea was clear: punishment for the guilty, but rehabilitation and education for the child. Right finger imagine, a child found working in a match factory at Sivakasi. After this judgment, the employer not only faced fines but also had to fund the child's schooling. The Supreme Court also ensured working hours for children in non-hazardous jobs were capped at 6 hours per day, with 2 hours for compulsory education, and all education expenses to be borne by the employer. Monitoring of these directions was entrusted to the Ministry of Labour, which regularly reported compliance to the court. Let's look at some figures. As per the 2011 census, India had 259 million children aged 5 to 14 years. Of these, about 10 million were working. Encouragingly, child labour declined by 2.6 million between 2001 and 2011, mostly in rural areas. But the worrying part is that child labour in urban areas increased, reflecting rising demand for cheap domestic or menial work. States like Uttar Pradesh, Bihar, Rajasthan, Maharashtra, and Madhya Pradesh account for over half of India's working children. Globally too, child labour remains a challenge. As per ILO data, 2012, there are still 168 million child labourers in the world. In summary, the 2016 amendment and the Supreme Court's 1996 directions together reshaped the fight against child labour, combining legal prohibition, stricter punishment, rehabilitation funds, and educational guarantees. The message is simple but powerful: children belong in schools, not factories. Dear viewer, if you found this video useful, we kindly request you to subscribe to our channel. Your likes, comments, and shares truly encourage us to create more such content. For free PDF notes and free multiple choice question practice on this topic, please visit our website. The link is provided in the description box. Thank you so much for watching and supporting us.